Hello, lovely listeners, and welcome once again to the Community First podcast, a BPA podcast where we have legal and social conversations with the community. My name is Priscilla Wepia Ametame, a legal associate at B&P Associates. Today, we will be discussing the topic Severing Ties in the Workplace, All You Must Know. And this is part of a two-part series that focuses on termination of employment and disciplinary hearing. Today, we have a very special guest with us in the person of Mr. Ernest Osei-Afful. Ernest is a corporate and commercial lawyer with extensive experience in business and human resources. As a lawyer with a business and human resources background, he seeks to synthesize law and business to achieve cutting-edge solutions tailored to specific business needs. He is currently a senior corporate counsel within the multinational space, and he has been very instrumental in handling legal issues, cross-border transactions, commercial contracts, and legal transactional services across various sectors. Additionally, Ernest is a chartered human resource management practitioner with the Chartered Institute of Human Resource Management, Ghana. We are very confident that Ernest has a lot of information to share with us today. And I believe you are as excited as I am to delve right into this conversation and to have an insightful conversation with Ernest. So Ernest, welcome to Community First.
Thank you so much. Wempia.
Wepia.
Forgive me, I always get to butcher names, but forgive me, I'll get there.
Yeah. So we're just going to dive straight into it. What does it mean to terminate an employment relationship?
Yes, so I'm sure you've all heard this song, The Terminator. Yes, that's a bad song now. So essentially, to terminate is to bring to an end, sort of. So if you are terminating employment, you are basically bringing the employment relationship between the employer and the employee to an end. You are severing the relationship by so many means.
Okay, so who can terminate an employment relationship?
Well, so as you said, the employment relationship is a contractual relationship. There's a contract between the employer and then the employee.
Yes.
And just as in any contract engagement, the parties to the contract can bring an end to the contractual relationship. So the employer and the employee are the primary parties to bring an end to the employment relationship. Of course, there may be other supervening events and all that, but essentially it's the employer and then the employee.
Oh, okay. So would you say that a reason must be given for termination of employment, or you can just terminate without giving any reason?
Well, this is a very interesting phenomenon in the employment law because people have been buzzing around that my employment was terminated and my employer did not give me a reason. And the question I asked them is, when you wanted to leave, did you also give them a reason before you left? And so we should always know that it's a two-way traffic. Just as the employee can walk out of the relationship, the employer can also end the relationship. So barring any contractual requirements or legal conditioning, generally, a party, whether the employer or the employee, can terminate the employment relationship without giving reasons. But of course, subject to the contractual and other statutory requirements between the parties.
Okay, so in case a reason is given for the termination, what would you say would constitute a valid reason for termination?
So a valid reason is a reason that is in accordance with law or in accordance with the terms of the contract. So generally, there are so many ways of bringing the employment relationship to an end, as maybe we'll look at it subsequently. But you can mutually agree to end the employment relationship. In that case, the reason is that you have mutually agreed.
Okay.
It is also valid if you look at Section 15 of the Labour Act. I promise not to talk too much law to make it simple for everybody to follow.
Thank you.
Yes, but it says that if you are unwell, if the employee is incapable due to ill health, then the relationship can be terminated. If, for instance, there is incompetence on the part of the worker. If, for instance, your work has been displaced by AI in today's terms, for instance, there will be no work for you to do.
Very important.
So you can't do. And then if there's a proven misconduct
Yes.
and has been, we've gone through the process and realized that you are guilty of a proven misconduct, the employer is entitled to terminate the employment. And then Section 65 of the Labor Act also talks about redundancy in case of there's amalgamation changes due to technology, due to operational and other reasons. The relationship can be severed as well.
Okay, so can you walk us through a termination proceedings? What are some of the legal procedures that an employer must follow when they take the decision to terminate the employment relationship with one of the employees?
All right, so I will keep referring to this expression that the contract between the employer and the employee determines almost everything. So sometimes you look at your contract of employment, or if you want to call it terms of employment or conditions of employment, it will determine, including other things, exit. That is termination of employment. So if you are terminating the employment, you have to follow the processes laid in there. There are other circumstances that will determine as well, but generally, you require that you give notice to the party. I think that is a very fundamental requirement. So you give notice to either the employer, if it's the employee terminating, if it's the employer terminating, you give notice to the employee in accordance with the agreed terms. Once you give notice, for instance, if your terms of employment says you should give 1 month notice or 3 month notice, as I have mostly seen, you can give notice for that period of time. Okay. If you are not willing to give that period, then you pay the person the salary in lieu of notice, as we say. So for instance, you pay him 3 months notice, 3 months salary instead of the notice, or 1 month salary in accordance with what is required. And then once you give that salary, that is, you are actually covered. In other cases, for instance, redundancy, you are required, for instance, to give a notice of the redundancy procedure or the redundancy act to the chief labor officer, who is a government appointed officer, that the labor department, that indeed you are going to embark on redundancy, and the law requires that you give him a 3 months notice, and then you give a similar notice to the union if there is a union at the workplace. If there's no union, the school of thought whether you should give the notice to the employee but you give them some notice. But what is cast in stone is that you give the notice to the chief labor officer and then the union. Once you've given the notice, you go through, you engage the workers, agree on the redundancy pay, and then once all of those things have been agreed, you sever the relationship by signing the exit agreement or the redundancy agreement.
Okay, so you keep talking about following the contracts of employment or the terms and conditions. Some people work in the informal sector and they may not necessarily have a contract. So what kinds of terms will govern termination in these kinds of cases?
Make no mistake, the fact that you don't have a contract of employment does not mean there is no contract between the parties. If you look at Section 13 of the Labor Act, for instance, every employer is required to give a contract of employment in a form prescribed in the Act. If you look at the Schedule 1 to the Act, it indicates the nature of the contract. The nature of the contract is determined there. So you have to look at that. For instance, the name of the employer and the employee is determined there. The work he's coming to perform, the role he's coming to play, how much you are going to pay him, the conditions of the work, annual leave requirement, in disciplinary, any other such requirements must be stipulated and handed over to the employee. If you fail to do that, you have actually breached the law, and the employee can take you or report you or petition the Labor Commission in that regard. But generally, that is a fundamental requirement. So there is a statutory contractual framework that has been laid out, which you need to comply with.
Oh, okay. That's very interesting. Does being a member of a union impact the termination of employment in any way. So, for example, if I'm in a union and my employer wants to terminate my employment, can my union protect me? Does that really affect the process in any way, and how?
Yes, so of course we say in losing terms, they say there's safety in numbers.
Yeah.
Normally, if you negotiate your contract individually, you may not be able to negotiate the best way out for yourself. But if you negotiate as a group in a collective bargaining manner, as we say, you come out with what we call the collective bargaining agreement that will determine the terms that should govern all the rights and responsibilities of the parties. And once the union negotiates the collective bargaining agreement, that supersedes any other contractual document between the parties.
Okay.
So it is encouraged that where there's a union, you join and then you negotiate together as a group. Okay. And the rights that the union is able to negotiate applies to all the employees in that class. Okay. Now, if you want to be part of the union, of course, you're right. Every employee has a right to join or to even form a union. Okay. And the union's activities are also protected under the Labor Act. So the union itself, its activities, and the to the extent that even the employer is supposed to facilitate the union's activities and how they organize themselves and all of that. Really? Yes. So yes, if the union is going to manage their affairs very well, then they are going to be able to secure the interest of their employees in a better way than one single individual will achieve. Let me also add that if you look at the union organizations like Trade, TUC, NAGRAT, TEWU, UTAG, and all the other trade unions that we have, they have proper structures. They're able to hire consultants and professionals to help them defend the right of their members. So if you're a member of such a group, just imagine one doctor fighting the Ghana Health Service or the government against the entire Ghana Medical Association fighting the government or negotiating with the government. It's so much easier, better, and safer in having a union.
Okay, so just to be clear, where a union exists under an employer, an employee specifically has to be a member of that union. So if you're not a member, if there's a union at your workplace and you're not a member of that union, then the union cannot protect your rights.
Yes, so as I indicated, if you look at the Constitution, it guarantees freedom of association. The Labor Act replicates that by saying that every worker or every employee is entitled to form his own union if he wants to, or join an existing union. And once you join or you become a member, you also enjoy what they negotiate. If you are not a member, they can extend whatever they negotiate to you, but it's not all the time. Okay. Yes, but of course, as a member, you are entitled to all the agreements that they are able to secure for its members, and then the facilities available to union members. And I should say that the benefits of joining a union actually goes beyond just the agreement and the collective bargaining agreement. Of course, you belong to an association that takes care of several other entitlements. I know, for instance, the teachers union, they have credit unions, they have retirement opportunities and other things that benefit those who are members. So definitely, if you're a member, you are able to benefit from all these facilities. But of course, you also have the responsibility to pay your dues.
Yes, of course. So would you say that there are differences in the termination procedures for different categories of employees? So we are looking at permanent employees, temporary employees, or contract workers. Are the termination procedures for these different categories different, or are they the same across the board?
Okay, so I would say yes, largely. And if you even look at the periodic work, if for instance you have a permanent employment, generally speaking, that you are paid monthly and all that, your notice period should not be less than a month's notice.
Okay.
Yes, if you worked for 3 years and above and all that. So if your employment is, let's say, week to week, you are paid weekly based on the employment scale, your notice period should be a week's notice.
Okay.
If your employment is as we go, pay as you go. So, for instance, you are just a day by day worker, as we call them, then at the end of the day, we can tell you tomorrow, don't come.
Wow.
That is it. But of course, so there are some distinctions that we need to make between permanent workers and then temporary workers. If you look at the law, it says that permanent workers are employees who hold employment contract with the employer for a period of time not predetermined.
Okay.
Or indefinitely. So it depends. And then the temporary workers, normally these workers, we have the casual workers and then the temporary workers and all that. So it depends. If you go to, for instance, the cocoa farm at Sefi, for instance, where the cocoa, during the cocoa harvesting period, they will take some temporary workers to do some activities and all that. Their terms of employment is totally different from somebody who has been hired as a nurse, hired as a banker in a bank with a formal employment for a certain period of time.
Okay. So let's delve straight into wrongful termination.
Okay.
Can you tell us what is wrongful termination?
Termination, that is wrong. I know. So yes, I kept saying that employment is governed by contract or by statute. That's law. So if your termination does not sit in line with the terms of the contract or in accordance with statute, with what the law says, that's wrongful termination. So we're looking at the law has defined this variously, but essentially, let me just keep it simple. Employment that is against the tenets of the contract or law. Okay,
so what are the remedies available to me if my employment is wrongfully terminated?
Three things. If your employment is wrongfully terminated, the employer can be asked to reinstate your employment, to bring you back. If your employment is not available, for instance, your employment can be asked to re-employ you in a similar role. Or a role that is commensurate to what you were. That's suitable to your role, the role you used to play. Or what is the most popular one is to compensate you for wrongful termination.
Okay. Yeah. And what is unfair termination? I've learned that unfair termination and wrongful termination are two different concepts.
Yes.
Can you walk us through?
Yes. So they are different because the Act has defined them differently. Okay. Wrongful termination, like I said, is basically contrary to law or contract. Unfair termination have specifically been defined under Section 63, 62, 63 fair and then unfair termination. So, for instance, if the termination of your employment is as a result of you mentioned union. Yes. So if you're a union executive and you are defending the rights of your members and because of that the employer doesn't like you, it is unfair termination. Okay. If you are discriminated against as an employee, that will constitute wrongful unfair termination. For instance, if you decide to fight for your right as a worker at the Labor Commission or at court and your employment is terminated, that's unfair because there should be fairness. The concept is that there should be fairness at the employment environment. Yes. You should treat each other fairly, equitably, without discrimination, without preferential treatment, and not victimize people or try to make them feel like they can't behave in a certain way because you don't like them. Yes. There should be a very free, friendly, fair, and just environment for everybody to practice his or her trade. Yes. So if you go contrary to these general tenets, then you are being unfair to the employee. And a termination that results from that treatment will be construed as unfair termination.
Okay, so in such a situation, what remedies will be available to the employee?
Yes. So the remedies for unfair termination are the three remedies that I spoke about.
So yes. So the type of remedy.
Exactly.
Okay, great. Are there specific considerations or protections in place for employees who are facing termination due to restructuring or downsizing? So we mentioned redundancy earlier. Are there any protections in place for those employees who are going through these proceedings or this process?
Absolutely. Redundancy is a special creature, and since the COVID time has become one of the popular topics because companies have had to downsize, have had to amalgamate, merge, acquire others and all that. So essentially, let me just take us back a bit. Redundancy is looking at loss of employment that happens as a result of changes in the organization's existence. So for instance, there is technological changes, and that means that people are going to lose their job. If customer service jobs are going to be performed by AI and all that, you can imagine the number of people who are likely to lose their jobs. So that's one. If companies are acquiring each other, that's merger and acquisition and all that. So these are redundancies. And of course, companies don't just wake up to pursue redundancy activities. And the law requires that before you anticipate redundancy, you have to also count the cost as a result of workforce. Okay. So you know that you are going to lose a certain number of workforce as a result of the redundancy. You give notice to the labor officer, as I've said, and all that. If you fail to go through the processes as required by law, and you don't pay the workers the redundancy pay in line with the Labor Act, Section 65 of the Labor Act, then the employee can actually petition the Labor Commission to defend their cause. Okay. If in some instances, if it goes into the computation of the redundancy benefits and all that, the Labor Commission will do that. But in all other cases, you have to go to the High Court, and the High Court will determine whether the process, whether everything else was fair or unfair.
Oh, okay. Wow. That's very, very insightful, considering that for us lawyers, it's become a very big topic in recent times, and we are dealing with more clients and more people who are going through these redundancy proceedings. So how would you say discrimination laws in Ghana influence termination decisions and procedures? So I'd say this question is flowing from the unfair termination question.
Yes. So it's actually, in my view, it actually goes beyond the fair unfair termination, because it has its very basis from the Constitution. The Constitution requires that nobody should be discriminated against, nobody should be preferred against the other on the basis of gender, height, face, where you're coming from, the food you like, the face, and all those kind of things, or the God you worship or the God you don't worship, and in all these instances. So yes, nobody should be given a fair treatment predominantly because of any of these conditions. The one interesting thing I would say is that if you look at the law, it indicates that to discriminate means to give different treatment to different persons attributable mainly or solely on the fact of any of these indicators.
Okay.
So if I am doing a recruitment, for instance, and I take Wepia because he comes from my hometown or my village, and I discriminate, that is discrimination, because that is the sole contribution that influenced my decision. If I decide to let someone go or promote another person because maybe she attends my church, or we are in the same old students union, or something of that, something as flimsy as a discriminatory factor, then that will be, and once discrimination is alleged, that will be an unfair termination. If it's a termination, if you are recruiting, and in recruitment too, discrimination it comes in, because if you pick somebody against the other, that will be discrimination against them, and the court will order you to there are so many orders that the court can make depending on the nature of the case that is before the court.
Okay, that's very insightful. In a nutshell, what would your concluding advice to both an employer and employee be regarding the termination of employment?
Well, it's a very interesting issue to talk about, because on a good day, an employee doesn't want his employment to be terminated. On a good day, the employer doesn't want his best worker to walk away. But it's a relationship. Yes. And in every relationship, we should also think of the exit strategy. in as much as the employer has the right to terminate, the employee also have the right to walk away. And the first thing I will say is that always go back to your contract of employment. Go back, look at the statute or the laws governing the employment. Look at whether there is a collective bargaining agreement. There are manuals and policies regarding your employment. Look at them. What do they say about termination? What kind of termination are you considering? Are you just doing termination simplicity? Are you doing termination by way of a disciplinary program, or redundancy, or not? These may have different outcomes.
Yes.
So consider the approach or the path you are taking as an employer. Employee is mostly one way out if you are voluntarily walking away. But in all this, look at your contract. The contract may even have certain conditions. Sometimes there may be what we call restraint of trade. There are some jobs that they will tell you that if you leave my employ, you cannot do similar work for a certain period of time, or you cannot do this or that or that. So look at your contract and understand it. If you don't understand it, you are always free to ask a lawyer to help you explain to you of your rights and your obligations as you walk out of your employment.
Okay. Thank you very much, Ernest. This has truly been a very, very insightful conversation. I've learned a lot, and I'm sure that our listeners have too. Just to highlight the conversations, we've discussed the different ways employment relationships can be terminated. We've also looked at labor unions and how they defend or protect the interests of their members. We've also considered unfair and wrongful termination, what the differences are, and what the legal implications of these two types of terminations are. And we've also considered redundancy. I'm very sure that the listeners have, acquired a lot of information from this session. And we look forward to speaking to you again in the second part of this series. So I encourage everyone to stay tuned for the next session, which will be focusing on a different aspect of the same topic of labor and employment matters. Thank you very much. And this has been the BPA Community Affairs podcast.